fake it. My heart is so cold, my energy is contagious. All the pain, I can't take it. I'm staying grounded and grateful, cause I know everything that I've been through only made me. Counting my blessings daily, yeah, they been acting shady, but I don't take it personal. The memories fading, I'm enjoying the moment. I've been smelling the roses, taking time to reflect, stepping back, the truth unfolding, stand low, got nothing to prove, cause I'm not the blow. I've been in the booth, speaking through my soul. You know that I'm true, either way it go, either way it goes. I cannot turn cold, staying on the low. I've been protecting my soul. If your intentions are not pure, I can't let you get too close, cause I'm vibrating high. Ain't got time for your ego, these niggas quit to turn their back. Acting like the amigos, they never cared in the shows. Wasn't with you at your low, assuming that you gonna fold. But baby, I've been growing ever since I let you go. And I've been doing better, and I know that hurts to know. Hurts to know. Only good vibes around me, and that's for sure. Me good vibes, good vibes, good vibes, good vibes. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes. Can't lie. Only need good vibes, good vibes, good vibes, good vibes. You see me searching for my inner peace. I've been learning more about myself and my purpose. Truth always come to the surface. Was hurting, but I had to heal. Releasing all the pain that I always held. Been going through some changes, I'll make it still. Protecting my soul to keep it real. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes, good vibes, good vibes, good vibes. Only need good vibes. Can't lie. Only need good vibes, good vibes, good vibes, good vibes.
You're a liar, a piece of shit, and I hope your ass is happy with all the trouble you caused.
All right. Welcome in, everyone. Yes, indeed. Today is Monday, October 30th, and it is still in the AM on my side, probably after lunch on your side, no matter what time it is. Damn, you never know what page is going to turn as the days go by. It's a different day. It's a new day here. This is very, very interesting. And all we're going to do today, forgive me, I'm not reading the chat. Okay, just forgive me on that. When you guys have a ball in there, do what you got to do. I'm going to get right into it and reading this document. And then we're going to wrap it up. I'm doing this so that if you're at work or if you're busy, you don't want to read, you can just sit back, take a listen, and we're going to see what's being brought to the Supreme Court here. You're going to sit down, take a listen at this. I'm going to scroll through it on the screen so that you are able to read along if you choose to. This is going to be a quick one, all right? And so here we go. This is breaking. Really couldn't believe my eyes when I read through it. And, we'll see where it goes. But we'll get started, and I think you're going to be really surprised by some of what's in here. So forgive me as I read through. I may be sipping on this coffee. And it is the Profi coffee. And so, like everything, it's organic, strong, sweet, and creamy. So, it truly is the Profi coffee. So welcome in, everyone. Grab your coffee, whatever the hell beverage you want to be consuming. If you're at work, apologize. But, just put it on in your earbuds, and we'll figure out what is being related here. Before I get started, welcome to everyone in the chat. I've seen you. Okay, I've seen you. Criminally Focused, Christine777, K West, my man, Fur Baby Daddy, the Baby Daddy, Amy Celeste, thank you so much for coming. What we got? Precoscent. Maya Sodas in the house. And anyone else? Okay, anyone else coming in? Like I said, I can't really follow along. We'll be busy reading. Oh, Blondie22 and Marianne Foster. There you are. Love you, girls. Oh, apologize. People just want to blow me up. But Champagne Poppy, everyone coming on in. Thanks for what you're doing. And I appreciate your presence. And I'll get busy reading now. Stop wasting your time. So here we go. What up? What up? Nobody, nothing. 1717. And anyone else come on in? You guys greet them because, like I said, I'm not going to be watching that chat. But let everyone know that we appreciate our presence. If you're a mod, anyone comes out here off the chain acting inappropriately, deal with them. So let's take a look. We got the table of contents. Well, let's back it up again. It's the relator's brief in support of the petition for writs of mandamus and prohibition. And here we go. Okay, table of contents. We got the background. Hundreds of documents improperly excluded from public access. Yes, indeed. Allen files the Frank's memorandum of law, and the trial court sua sponte removes it from public CCS without notice or hearing. Wow. The trial court attempts to effectuate the removal of Allen's chosen counsel over his objection and without his consent or approval. That's what we've all been upset about. Allen instructs his chosen counsel to make filings on his behalf, and the trial court orders a clerk to remove the filings from both CCS and the electronic case file. Wow. Grounds for writs of mandamus and prohibition. Original action standards. 2A. The trial court must act contrary to an absolute duty imposed by law and condition precedent for original actions. 3. The trial court has failed to perform the clear and absolute imperative duty imposed by the access to court records rules and the trial rules. 3A. The access to court records and the trial rules require court records to be publicly accessible. And B. The trial court continues to violate these absolute duties by improperly removing documents from the CCS and excluding public access to documents filed in this case. B1, removal of court records from the CCS is never allowed. B2, there remains a lack of meaningful public access in this case. And conclusion. Now, question here. What are they hiding? What have they been hiding for 6+ years? Okay, background. Hundreds of documents are improperly excluded from public access. This case involves one of the most high-profile matters in Indiana history. On April 5, 2023, defendant relator Richard Allen filed an emergency motion to modify safekeeping order, exhibits, and a proposed order, marking everything as public documents. And here, let's see if I can blow this up. Okay. This appears to be a screenshot of some of the documents. And you notice there, April 5, 2023, 10:39 a.m. Okay. Thereafter, someone within the court system, now pay attention, someone within the court system, sua sponte, changed all of Allen's filings to confidential and excluded all of them from public access without any notice to or from Allen. Record, page 15. From that point through the end of June 2023, more than 125 separate court orders were excluded from public access. Record pages 15 through 23. But not a single one of these excluded documents includes the mandatory access to court records ACR form identifying the specific Rule 5 grounds upon which exclusion is based. Indiana Access to Court Records, Rule 5B. As of today, October 30th, 2023, there is no way for the public to know the grounds on which any document was excluded. On June 8, 2023, a member of the media requested access to these excluded court records, record pages 38 to 40. On June 28, 2023, the trial court ruled on that motion and explained that all of the documents had been excluded from public access to comply with the court order dated December 2, 2022, which prohibits public comment, commonly referred to as the gag order. Record page 42. This gag order, however, only governs extrajudicial comments, not court filings. Let's reread that. On June 28, 2023, the trial court ruled on that motion and explained that all of the documents had been excluded from public access, quote, to comply with the court order dated December 2, 2022, which prohibits public comment, commonly referred to as the gag order. This gag order, however, only governs extrajudicial comments, not court filings. The trial court then allowed parties to agree to exclude the entirety of certain records from public access, even though both actions are prohibited by the access to court record rules. First, a court cannot exclude records otherwise accessible to the public because the parties agree to do so or because the parties have entered into a trial rule. 26C Protective Order. Access to Court Record Rules, Rule 5. Commentary. Second, unless everything in the document can be properly excluded from public access, the document cannot be excluded in its entirety. Rather, there must be a public access version and a non-public access version. And the public access version has the confidential information redacted. But all of the non-confidential information in the document is still publicly available. With regard to the other documents that have been improperly excluded from the public access, the trial court did not order the clerk to make the documents on the CCS public, something that clerks do all the time, which it would have allowed the public to identify the filings they wanted and then access those particular filings. Instead, the trial court created a link, allensuperiorcourt.us/Delphi/ and uploaded a zip drive containing the 118 documents. Although the 118 documents were all filed sometime between April and June, every document in the zip drive has the date of 6/27/2023. Record pages 47 to 50. More problematic, the file names have no clear identifying information to let someone know what that document actually is. And none of the exhibits to a particular filing are anywhere near the actual filings. Okay, then there's a huge list of the 118 documents. We'll go through that. Okay. Moreover, many of the file names are so long that they cannot be extracted, which makes the document inaccessible. The actual CCS in this case still has every one of the 118 documents excluded from public access. This means the only way a member of the public can access anything in this case is if they somehow know how to read the June 28, 2023 order. See the link embedded therein, and then proceed to open each of the 118 documents until they find the filing they are looking for. In addition to the items the trial court allowed the parties to exclude by agreement, there are two more documents that remain excluded. are not on the zip drive, and do not have an ACR form, and for which an ACR Rule 6 hearing has never been held. 1. A June 20, 2023 filing by the Carroll County Sheriff, and 2. A July 5, 2023 letter from a DOC inmate. Record pages 22 to 23. More recently, on September 25, 2023, the state filed a motion to exclude all future filings from public access until the court conducts an in-camera review of each filing. And the state then excluded even that motion from public access. Okay, complete block under the blanket of gag order. The trial court has neither ruled on this motion nor set the matter for an ACR Rule 6 hearing. One B. Yeah, it's a hot mess. It is a hot mess. What do they not want us to know? Allen files a Frank memorandum of law, and the trial court, sua sponte, removes it from the public CCS without notice or hearing. Here we go. On September 18, 2023, Allen made what is known as a Frank's filing, wherein a defendant seeks to present evidence that the officer who prepared the probable cause affidavit, i.e., Mr. Liggett, misled the court to believe the probable cause ever existed. See Franks versus Delaware, 438 U.S. 154, 1978. Allen filed 3 documents with this Franks filing. 1, the motion. 2, the memorandum in support. And 3, the exhibits list. And here we go. Hopefully you can see this. Okay. The summary above shows that the memorandum was filed as a public document, but someone within the court has removed/excluded the 136-page Franks memorandum from the CCS altogether, again with no notice to Allen. One C. The trial court attempts to effectuate the removal of Allen's chosen counsel over his objection and without his consent or approval. In early October 2023, counsel for Allen learned that Mitchell Westerman had surreptitiously and without authorization photographed crime scene evidence in this case that was being stored in Allen's attorney Andrew Baldwin's office, and then disseminated those photographs without attorney Baldwin or Allen's other attorney Brad Rossi's consent. Record page 191. Attorneys Rossi and Baldwin immediately informed Allen of this theft, and Allen unequivocally informed the trial court that he still wanted these attorneys to represent him and that their representation to date had been in his best interest. There's the letter. Let's read it. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley A. Rossi, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that images of crime scene photos and other related documents, like we've been saying parenthetically, were taken by a friend and former employee of Andrew Baldwin at attorney Baldwin's office, i.e. Mitch Westerman. I have discussed with attorney Rossi the potential impact that the distribution of these documents could have on my defense. Attorney Rossi has also communicated to me that the prosecutor has requested that my attorneys be disqualified from representing me in this case. I do not wish this to happen. I want Mr. Baldwin and Mr. Rossi to continue to represent me until this case is resolved, one way or the other. I believe that they are acting in a manner that is in my best interest. I appreciate your time and consideration in this matter. Respectfully submitted. Now, I am sure that the attorneys drafted this letter and he signed it. Regardless. Okay. Attorneys Rozzi and Baldwin also immediately informed the prosecutor and the trial court of this theft, as they should have. Record pages 190-193. The trial court set a hearing for 2 p.m. on October 19 to discuss, quote, these recent developments. Record page 191. Despite Allen's express instructions to the contrary, on October 12, 2023, the trial court sua sponte ordered Rozzi and Baldwin to cease work on Mr. Allen's case and scheduled an in-chambers meeting for 12:30 p.m. on the 19th, 2023. This 12:30 meeting is not noticed anywhere in the CCS. Record 26 to 29. Prior to this meeting, now listen closely, okay? I'm sure you all have read this memorandum that he filed. Prior to this meeting, Attorney Baldwin filed a memorandum explaining the circumstances regarding the photographs and the fact that not only was Attorney Baldwin, quote, snookered and abused, which I found hilarious, and betrayed by theft, but more important, nothing has been disclosed that won't be disclosed at trial or hearings. Record pages 197-201. Attorney Rozzi similarly provided the trial court with a letter outlining what happened and enclosed the letter above from Allen, stating he wanted attorneys Rozzi and Baldwin as his attorneys. Record, page 26 and 230 to 231. During the October 19, I apologize. Okay. During the October 19, 2023 in-chambers, now pay attention here. How's everyone doing? Okay. During the October 19, 2023 in-chambers meeting at which Allen was not present, even though he was in the courthouse and his presence had been requested, the trial court read a prepared statement to attorneys Rozzi and Baldwin, accusing them of gross negligence in their capacity as Allen's counsel. I have not seen that letter. You have not seen that letter. We would love to see that letter. These purported acts of, quote, gross negligence included efforts by the defense to level the playing field with a press release after the prosecution filed multiple releases, filing motions to protect Allen's basic human rights, motions that the trial court either granted or that remained pending, filing the Franks memorandum that the trial court believed contained improper statements, filing a tort claim notice to preserve Allen's rights to seek redress from conditions and treatment related to his incarceration, which is obviously improper. A third party's unauthorized photographing of the crime scene evidence, which neither attorney had knowledge nor participated in, and which I believe. Record pages 223 to 24. Okay, now here we go. Pay attention again. After reading from this prepared statement, the trial court then informed attorneys Rozzi and Baldwin that they had two options. One, they voluntarily withdraw their appearances immediately, or, here's the important one, the trial court would read the prepared statement into the record on camera and then disqualify both attorneys in open court. Shame tactics, coercion, intimidation. Record page 230. Attorneys Rozzi and Baldwin were shocked and asked to meet with Allen before making any decisions. Allen reaffirmed that he did not believe attorneys Rozzi and Baldwin had engaged in any negligence, much less gross negligence. Allen also reaffirmed his desire to move forward with attorneys Rozzi and Baldwin as his sole counsel, and objected to the trial court's attempt to strip him of that counsel. Okay, now I understand they are trying to minimize the negligence, and there was clearly negligence. Okay. After speaking with Allen, attorneys Baldwin and Rozzi returned to chambers, now pay attention, and articulated that they believed the trial court had engaged in an unconstitutional ambush of defense counsel without due process. Page 231. They informed the trial court that any withdrawal would be involuntary and under duress. because the trial court had made it clear that if they did not agree to withdraw, the court would disqualify them in open court in front of the cameras. And this is where I believe they are stating fact. Attorneys Baldwin and Rozzi believe that this placed them in an impossible ethical bind, record page 232. If they did not withdraw in chambers, quote, the trial court would publicly, that meaning on TV, disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light, quote, on camera. They believed that such a public statement from the trial court risked tainting the jury pool, which I do believe, harming their client's defense, which I do believe, undermining the professional relationship with the client, and possibly creating an actual conflict for their continued representation. Faced with this dilemma, Attorney Rozzi informed the trial court that he would file papers regarding his withdrawal at a later date, and we know that. And Attorney Baldwin orally made a motion to withdraw, and we know that. Allen instructs, oh, my apologies. Okay. Allen instructs his chosen counsel to make filings on his behalf, and the trial court orders the clerk to remove the filings from both the CCS and the electronic case file. After the events of October 19, 2023, Allen instructed Attorney Rozzi to file the notice on October 25, 2023, indicating that Allen did not want him to withdraw as counsel. Record pages 229 to 232. This notice informed the trial court that there were no circumstances under Rule 1.6 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rozzi's representation of defendant Allen, and that everything cited by the trial court as constituting the alleged gross negligence was either not attributable to Attorney Rozzi or was the product of ethical lawyering in the best interest of the client's defense and mental and physical well-being. Again, a defense position, but let's continue. This notice also stated that Allen was asserting his constitutional right to counsel of his choice and wanted Attorney Rozzi to move forward with the representation of defendant Allen until a final disposition of this matter. Record page 232. The notice further pointed out that unless Attorney Rozzi was allowed to continue as counsel of record, the jury trial set to commence on January 8, 2024, which is already a full 15 months after Allen's arrest, would have to be continued, which would unreasonably prejudice Allen and, might I also add, put his life at further risk. Allen also instructed Attorney Rozzi to file a motion seeking the trial court's recusal and a motion asking for a continuance of the October 31, 2023 hearing because of the many unresolved pending motions in the case. Record pages 220 to 227, 235 to 36. Notwithstanding these filings, on October 27, 2023, the trial court issued the following order declaring that Attorney Rozzi is no longer counsel of record and ordering the clerk to remove all of Allen's filings from both the CCS and the electronic case file. Now let's read this. Court notes filings by former Attorney Rozzi on October 25 and 26, 2023 and takes no action. Attorney Rozzi withdrew from this matter on October 19, 2023. No, he did not. And is no longer counsel of record. These filings, therefore, are ordered stricken from the record. The clerk of court ordered to remove the pleadings from the electronic case file and the chronological case summary as being filed in error. And yes, she apparently backdated. We'll get to that later. Anyone need a smoke break yet? Basically, Your Honor, what in the hell? All right. Now, grounds for writs of mandamus and prohibition. Original action standards. The trial court must act contrary to an absolute duty imposed by law. Okay. So how has this court acted contrary to the absolute duty imposed by the law? Original actions provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. I'll skip over the precedents here. You can read it for yourself. Writs are usually issued by this court in a wide variety of circumstances, such as to enforce court rules, effectuate the disqualification of a trial court, order a criminal defendant to be released from jail on his own recognizance, and address a trial court's failures to adhere to statutory mandates, meaning you can't do that. Writs of mandamus and prohibition have also been issued to address matters affecting the public trust in the integrity of judicial processes. Now let's read this precedent, because this is clearly a violation of the public's trust in the integrity of the judicial process. And what I've observed in the past week is that the people do not buy it. The people are rejecting it. The jury will be drawn from the people. The jury will therefore likely be made up of a percentage of people who have no trust in the integrity of the judicial process if this is not addressed. State ex rel. Kurtz versus Delaware Circuit Court number 5. Okay, read the numbers. Okay. Condition precedent for original actions. Okay. Counsel recognizes that Original Action Rule 2A contains a condition precedent requiring that the subject matter of the original action must be raised and ruled on by the trial court prior to filing an original action. This, however, is a practical impossibility in this case. Asserting his Sixth Amendment rights, Allen has only consented and authorized attorneys Rozzi and Baldwin to represent him in the trial court below, and only they are authorized to make filings on his behalf in that court. As noted above, however, the trial court refuses to accept any filings made by these attorneys and orders the clerk of court to remove anything they file. Accordingly, there is an impossibility of performance of the condition precedent. Allen believes this is analogous to the condition precedent in the appellate rules that a motion for a stay pending appeal may not be filed with the appellate court unless a motion for stay was filed and denied by the trial court. This condition precedent may be excused, however, upon a showing of extraordinary circumstances. The facts and current posture of this case rise to this level of extraordinary circumstance, and Allen therefore requests that the court similarly excuse the condition precedent otherwise required for original actions. Who would agree that the current posture and the facts of this case rise to the level of extraordinary circumstances? I mean, is it not red flagging all over the place? Have we not seen a series of extraordinary circumstances? I think it was laid out well in the first part of this document. Let's read this footnote. After ordering filings removed and over Allen's objections, the trial court appointed him new counsel, her buddies. Allen does not accept this appointment, and he has not authorized these new attorneys to act on his behalf in any manner whatsoever. The trial court has failed to perform clear and absolute imperative duty imposed by the access to court records rules and trial rules. Okay, here's important. The access to court records and trial rules require court records to be publicly accessible. The trial court rules mandate that the trial court clerk shall maintain a sequential record of judicial events in such proceeding, and the CCS must reflect all trial court events, which include any and all filings. Indiana Trial Procedures Rule 77B. In addition, this court has unequivocally mandated that Indiana court records are open to and accessible by the public, noting that there are strong societal reasons for allowing public access to court records, and denial of access could compromise the judiciary's role in society, inhibit accountability, and endanger public safety. And remember, we're reading from the perspective of the Supreme Court. These rules are designed to provide maximum public accessibility to court records. A court record is accessible to the public except as provided by Rule 5. This rule applies to all court records regardless of the manner of creation, method of collection, form of storage, or the form in which the record is maintained. To further this mandate, access to court records rules start from the presumption of open public access to court records, not sealing. Let's reread that. Access to court records rules start from the presumption of open public access to court records. Unless an entire case is excluded from public access, which is not at issue here, there are only two ways a court record may be excluded. One, it falls within the ACR 5B or C, in which case it is excluded as a matter of right. Or two, extraordinary circumstances exist and all of the requirements of ACR 6 are met. Okay, let's read footnote 12. The requirements include a verified request, public notice, public hearing, and a written order that finds the requester has demonstrated by clear and convincing evidence that any one or more requirements of Rule 6A have been satisfied. Balances the public access interest served by this rule and the grounds demonstrated by the requester, and uses the least restrictive means and duration when prohibiting access. Rule 6A requires that the requester must demonstrate that 1, the public interest will be substantially served by prohibiting access. Read it. The public interest will be substantially served by prohibiting access. 2, access or dissemination of the court record will create a significant risk of substantial harm to the requestor, other persons, or the general public. Or 3, a substantial prejudicial effect on the ongoing proceedings cannot be avoided without prohibiting access. Okay? Back to the document. As noted above, parties may not ever agree to exclude a court record that otherwise does not satisfy Rule 5 or 6. A court cannot exclude records otherwise accessible to the public because the parties, quote, agree to do so, or because the parties have entered into Trial Rule 26C protective order. We'll skip the precedents. Okay. Moreover, every confidential record must be accompanied by an ACR form identifying the specific Rule 5 grounds upon which exclusion is based. ACR 5B, quote, simply filing the document and locking it does not satisfy a notice requirement. A person looking at the case will see that a document is excluded in its entirety from the court record, and the person must also see ACR form stating what document was excluded and why. Similarly, unless everything in the document can be properly excluded from public access, there must be a public access version, meaning redacted, and a non-public access version of the document. The public access version has the confidential information redacted, but all of the non-confidential information in the document still must be publicly available. Finally, if a court determines that the court records are excluded from public access without first satisfying 5A, B, C, and D, or E, the court records shall be made available for public access 72 hours after notice to the parties and any person affected by the release unless the requirements of Rule 6 are thereafter satisfied. The trial court continues to violate these absolute duties by improperly removing documents from the CCS and excluding public access to documents filed in the case. In B1, removal of court records from the CCS is never allowed. All right. The trial court failed to perform a clear and absolute and imperative duty imposed by the trial rules and access to court records rules when it sua sponte removed and excluded the Frank's memorandum and also ordered the clerk to, quote, remove all of Allen's most recent filings from both the CCS and the electronic case file. This is simply not allowed under either set of rules. The trial court's beliefs that these filings are either improper or unauthorized does not justify the removal or exclusion of the court records from the CCS altogether. Let's reread that. This is simply not allowed under either set of rules. The trial court's beliefs. Oh, one moment, please. I apologize. Someone out there. The trial court's beliefs that these filings are either improper or unauthorized does not justify the removal or exclusion of the court records from the CCS altogether. This court need look no further than how Indiana's appellate court handles these situations. If an appellate court concludes that a filing is improper or unauthorized, it issues an order or opinion stating the same and does not consider the filing, but it does not remove or exclude that filing from the CCS. For example, most recently in the city of Carmel, Indiana versus Duke Energy, Indiana, the city of Carmel moved to strike the brief, contending it was an impermissible and unauthorized filing because the IURC was not a party to the appeal. The Court of Appeals agreed. Quote, by separate order issued today, we grant Carmel's motion to strike the brief of the IURC and its motion for leave to file a reply brief in support of its motion to strike. In addition, we dismiss the IURC as a party to this appeal because it is not a proper party on appeal from its own decision. But the appellate court did not thereafter instruct the appellate clerk to remove the IURC's filings from the CCS. Those filings are still there and accessible to the public because that is what the access to court record rules require. The bottom line is that the trial court may enter whatever order it deems appropriate to address any court records the court believes to be improper or unauthorized, and it may inform the parties and the public that it will not review or consider such filings. What the trial rules and access to court record rules do not allow is for those filings to be sua sponte removed or excluded from public access. Writs of Mandamus and Prohibition are therefore warranted to ensure the court records are placed back on the CCS, remain publicly accessible, and that these actions do not happen again. 3B2. There remains a lack of meaningful public access to this case. Yeah, no doubt. No doubt. What are they hiding? What are they hiding? Why have we never been able to see a thing? Unless it's leaked. As noted above, Allen's April 5, 2023 filings were marked as public documents. Someone within the court system, sua sponte, changed all of the filings to confidential and excluding all of them from public access. The next 3 months of court records were all improperly excluded from public access as well, also without the mandatory ACR form. On June 28, 2023, the trial court explained that all of the above pleadings had been excluded from public access, quote, to comply with the court order dated December 2, 2022, which prohibits public comment, commonly referred to as the gag order, which the trial court appears to recognize was improper because the trial court created a link to allensuperiorcourt.us/Delphi/ containing a zip drive with the 118 documents uploaded. This did not satisfy the trial court's duties under the access to court records rules. First, the trial court allowed the parties to agree to exclude the entirety of certain records from public access. Section 2A, supra, sets out how that violates Rule 5 of the access to court records rules in two different ways. Secondly, the zip drive does not provide meaningful access to public records, right? It provides very complicated, difficult, prohibitive access, in my opinion. The file names for the 118 documents have no clear identifying information to enable someone to recognize what document that document actually is. Every document has the same date of 6/27/23, and none of the exhibits to a particular filing are connected to the actual filings. It's in the record, page 47 to 50, pages 47 to 50. The actual CCS in this case still has every one of the 118 documents excluded from public access, pages 15 to 23. As noted above, this means the only way a member of the public can access anything in this case is if they somehow know how to read the June 28, 2023 order, they see the link embedded therein, and then proceed to open each of the 118 documents until they find the filing they are looking for. It's prohibitive. This does not provide the public access mandated by the access to court record rules. In addition, there are still two documents that remain excluded, are not on the zip drive, do not have an ACR form, and for which an ACR Rule 6 hearing has never been held. The June 20th, 2023 filing by the Carroll County Sheriff's Office, and two, a July 5, 2023 letter from a DOC inmate, pages 22 to 23 in the record. A writ of mandamus is needed ordering that the 118 documents must be made public accessible on the CCS itself, and that the two documents listed above may only remain excluded upon compliance with the access to court records rules. All right, babes. Catch your breath and let's read the conclusion. I mean, this is so clearly spelled out. This needs to be screenshotted, paragraph at a time here and there, and posted. You guys post this piece by piece, whatever you think is most urgent to your own sensibilities. All right, conclusion. Everyone good in that chat? If there ever was a time when the openness mandated by the trial rules and access to court records was critical, it is the present case. One of the most high-profile cases the state, Indiana, has ever seen. For many residents of Indiana, this is the first time they have followed the workings of a court in the state. Remember, this is possibly the biggest case Indiana has ever seen. We have prohibitive access to the court records. We have improperly sealed and gagged records. Yet the trial rules and access to court record rules have been repeatedly violated, leaving the public and the media in the dark. The public is losing confidence in the judicial system. A writ of mandamus or prohibition is appropriate to ensure that going forward this court's mandates regarding public access are followed without exception. So, what is this saying? Let's crack the door wide open. Let's remove the veil of secrecy. Let's properly document, file, and supplement and allow access to all of this. Submitted by Maggie Smith, Kara Winnicky, and Jesse A. Cook. Okay, attorneys for Richard Allen. Pursuant to Rule 3B of the Indiana Rules for Procedure for Original Actions, undersigned counsel certifies that the following contains fewer than 4,200 words, exclusive of the items listed in the Appellate Rule 44C as counted by the word processing systems used to prepare the brief, Microsoft Word. Pursuant to Rule 2D of the Indiana Rules of Procedure for Original Actions, the foregoing was electronically filed using the court's IEFS system on October 30th, today, was served upon the following through the Indiana electronic filing system and via electronic mail at the noted email addresses. And we'll skip this. If you want to email these people, I'm not suggesting you do, but you certainly are have the possibility to because they're right here. Francis Gall. Okay, Robert Scrimmin. William Librado. Slick Nick. And Theodore Rokita. All right. All right, watch your eyes. This is going to be a quick one. All right. I'm going all the way back. There we go. All right, in the Supreme Court of Indiana, State of Indiana on the relation of Richard Allen, Relator, versus the Carroll Circuit Court and Judge Gall. Filed at 10:54 a.m. Indiana time this morning. Let's take a look at the chat before I even get out of here. And I want to thank everyone for putting up with that. I know it was a long document, but God, it's rich. It is rich. All right. Let's see what we're looking at. Let's take a look at my people here. Say hello to everyone I missed. All right. Jaded Empath, welcome on in. Thanks for being here. I didn't notice you jump in. I was reading. Oh, Noe is in the house. Noe. What's up, Noe? Okay. Aaron Town, welcome in. Welcome in, Aaron. All right, good to see you. Oh, Amy. Hey, Amy. Welcome. Thanks for coming in, Amy. Digital. What's up, Digital? Thanks for coming in. All right. Milan, 1885. Welcome back. It's good to see you again. All right, you guys. Miss anyone else? I know I didn't miss Fur Baby Daddy. Oh, Carol. I don't know if it said hi earlier. Welcome in, Carol. Good to see you again. Yeah, that might be it. If I missed you, I do apologize. Okay. I never like missing anyone. Thanks, Blondie. Thank you. But you guys, I did post a link to this on the community page. And feel free, if you want to jump on the community page and click on that link, it'll bring you to the document. You can download it and have it for yourself. Read through it again. I did, honestly, I was rushing. Okay, I rushed right on through it. But I think if you go back through, especially the first half of the document, you're going to see that this is a very clear case, I think. They made a really strong case. And of course, there are some things in there that I didn't fully agree with, especially concerning the culpability, responsibility, or negligence of Baldwin in allowing, whether intentionally or unintentionally, Mitchell Westerman to violate these documents. But I tell you what, regardless of that passing off of the responsibility or shirking it, there's still it's a strong case in here, and I think that there's going to be a problem. Okay, so thank you, everybody. I hope you get to read it yourself and go click on that link, and if not, go ahead and listen to it again. And again, apologies for rushing on through it, but I want to get it done. And thanks for being here. Oh, did it expire? Okay, well, guess what? I saved it myself. So I'll put it in the Discord. I'll put an actual PDF in the Discord. So if you go in the Discord, I'll have a download link for the PDF, and it'll come from my server, not the state server. It's expired, meaning that probably so many people have downloaded it that they've reached the maximum downloads for the 24 hours. So I'll go ahead and throw it in the Discord so that you can have it for yourself and read it. Because again, I think they're making a really strong case here. And I appreciate that, because exactly what I was feeling, especially regarding the public confidence in the judicial system, that particularly, I mean, the two things is the prohibitive access to court records. Okay, I have a problem with that, and I think they make a strong case. And then the whatever else I was going to say. I'm done. I'm burned out. But God bless you all. See you at another time, and let's hear it from our detractors one more time. Whoa!
You're a liar and a piece of shit, and I hope your ass is happy with all the trouble you caused.
All right. See you guys another time. Say goodbye to each other in the chat, and we'll catch you later. Good day today. I think we got a good thing. This is a good thing going.